Mr. Waxman, it seems that you tie your analysis to knowledge of the Rana attacks rather than just general knowledge of terrorism.
So thank you, Justice Thomas. Let me clarify. We do not contend that there is no liability if these companies didn't know that the Rana nightclub would be attacked. What they had to have known to satisfy the operative language of the statute was that they were in fact providing substantial assistance to the act of international terrorism that injured the plaintiff, and that they knew that their action would substantially assist an act of international terrorism. The flight trainers who taught the al-Qaeda terrorists how to fly planes so they could fly them into the World Trade Center and the Pentagon didn't need to know that those were the targets. But he needed to know that he was in fact providing substantial assistance to people who aim to use that knowledge in order to commit a terrorist attack.
So, and I may have misunderstood your brief, but so you would, I assume you would agree that if I had a friend who was a mugger, a murderer, and a burglar,
hard to imagine,
but other than that, he was a good guy. And I loaned him a gun, but not knowing and not wanting to know what he was going to do with it, that possibly could be aiding and abetting.
So I think it wouldn't be.
Why?
Because while it would satisfy steps 1 and 3 of the Halberstam legal framework that is meant to be the model for the interpretive model for this statute, you also have to have a general awareness that you are assisting in overall illegal or tortious activity. So, for example, if I have a farm and I have a gate with my next door neighbor's pasture and it's got a padlock and I can't open the padlock, and I go to you, you're my neighbor on the other side, and say, Justice Thomas, I'm trying to open this gate, but I can't get the padlock open. Do you have any bolt cutters that could do this? And you say, yes, I do, and in fact, I'll cut the bolt for you. And I then use the open gate to steal my neighbor's sheep. You know that you provided substantial assistance to me in entering the property, but you're not culpable within the meaning of the common understanding of the word aiding and abetting, or under step 2 of the Halberstam doctrine, because you're not generally aware of your role as part of an overall illegal or tortious activity.
I think you've changed somewhat my example.
Oh, well,
my friend is a burglar, he's a murderer, and he is a mugger. And he says he has some business to conduct, and I loan him a gun. Now, that's quite different from opening the gate, because you can open the gate for quite a number of legal reasons and legitimate reasons. But if I know to moral certainty the kind of person my friend is, would I have to be more specific than that in order to be aiding and abetting his criminal conduct?
So I think in that instance, you would ask the question under the operative language of the statute, did you knowingly provide substantial assistance? Assume that your friend then committed a crime with the gun. That would be substantial assistance in the commission of that crime. But whether you knew you were substantially assisting the crime would involve a determination under the circumstances whether it was fair as a matter of law to permit an inference that you knew that although your friend was otherwise a good guy, he was in fact going to use it to commit some crime. Now, even that hypothetical is quite removed from the circumstances of this case, because that involved an active provision from one person to another of something that was, in fact, of substantial assistance. What
Well,
we
if I
have
could
here,
just-
I'm sorry, can I just finish my sentence?
Okay.
Okay. What we have here is an alleged failure to do more to ferret out violations of a clear and enforced policy against assisting or allowing any postings supporting terrorist organizations or activities.